Hello everyone, welcome to our class today. So today we are going to discuss one of the very important concept, that is initiation of criminal case. Okay, so let me give you an introduction. See, what happens is, suppose there is an offence has been committed. Okay, an offence has been committed, and when the offence has been committed, the person, he wants to give information to the authorities, right? He will give information to the authorities. So to which authority will he give? He may give it to the police, what we call as complaint, right? So but actually the complaint is different. As per BNSS, the meaning of complaint is a completely different thing. But let us understand, when an offence has been committed, the information is given to the police, right? Or sometimes it is given to the magistrate also. Even to the magistrate the information is given. Okay. So what kind of offence? See, when there are two types of offences, what we call it as. Okay. One is cognizable offence and another is non-cognizable offence. One is cognizable offence and another is non-cognizable offence. When cognizable offence means, see, it's a kind of a serious offence. We have to refer it to the first schedule of BNSS or first schedule of CRPC to understand what kind of offences are cognizable offences, what kind of offences are non-cognizable offences, right? This is one thing what we have understood. When that is the case, the police or when an offence has been committed, the information is given to the police with respect to the cognizable offence. When cognizable offence has taken place, when information with respect to the cognizable offence has been given, that is said to be FIR. Okay, that is said to be FIR. FIR is something which is known as first information report, and when a person gives information as to the cognizable offence to the police, then it is said as FIR. What is the difference? See, when information as to the cognizable offence has been given, police can directly start investigation. Immediately he can start investigation. He does not require anyone's permission. But when the information is with respect to non-cognizable offence, the police has to take the permission of the magistrate. First he has to, because those are less serious offences. Police do not have the power to start in the investigation. He can only receive the information, but he cannot start the investigation, right? So he has to intimate to the magistrate. Magistrate has to give the permission. Only then he can start the investigation. Otherwise, he cannot start the investigation. So that is the major difference between non-cognizable offence and cognizable offence. Okay. Yes. So FIR is something what we are understanding today, and also see, it can also go by other means also. You can also complain to the magistrate. So this is the real sense of complaint here. This is the meaning of complaint. Okay. When an offence relating to the magistrate, when an offence relating to the when a offence relating to the magistrate is given, that is said to be complaint. When an offence is the information relating to the offence is given to the police, then it is the information regarding cognizable offence, it is said to be FIR, or it is just an information with respect to the non-cognizable offence. Okay, so this is how, through this you are setting the criminal law in motion, because they will see what can be done next. Magistrate will see what can be done next. Investigation or inquiry or whatever process the next stage is, they will see what to do. Okay, so this is the initiation of the criminal case. This is the starting, this is the triggering of the criminal case. Okay, I hope this portion, this introduction you have understood. So likewise, we are going as per the syllabus. Okay, one syllabus as per the law, Karnataka State Law University syllabus, which is similar to most of the law university syllabus. This is the syllabus. So unit 1 we are covering. So under this, the chapter 5, the initiation of criminal case. So, we are learning about completely regarding the police in the direction of the police, like first information report, zero FIR, then investigation powers, preliminary inquiry, complaint. Complaint I have already explained while explaining definition, but this is one such thing what we have to understand. Okay, so this will be in 2 or 3 parts, chapter 5, because let's understand part by part so that we can classify the questions and all. When you get the questions, it can be restricted only to that much portion. Okay, so first let's understand what is FIR. So FIR has been given, the section relating to FIR is 173 of BNSS and 154 of CRPC. Whatever you can refer, because earlier we used to refer it by this section, so we cannot easily forget that section. Somewhere or the other the reference could be there. So that's why I like to refer both the sections in CRPC also and also in BNSS. So section 154 of CRPC and section 173. So be thorough with this section, very important and most common question asked in any law examination. They may ask directly regarding the section, or they may ask write some information about FIR, short note, or give a description like this the questions will be. Okay, so when it comes to the, like, what does this section cover? What does it say? So it says like how you can give an FIR, how you can lodge an FIR. Okay, that is one thing, and some sexual offences will be there. So when such sexual offences are committed and information is given to the police, then who has to record it? It has to be recorded by woman. It could be woman police officer or woman officer to save the victim from embarrassment. Okay, that is one thing. And sometimes if the victim is disabled, she or he could be mentally disabled, physically disabled, it could be temporary or permanent disability. There is a special procedure for that. It needs to be videographed. Some procedures are there. So, we will see that. And when FIR is lodged, the person has to get the copy back because he needs to have the copyright. So, it has to be supplied free. That is a very important thing what we understand. And another new concept which has been given, preliminary inquiry. What does this preliminary inquiry mean? This is a new concept. Okay, and also zero FIR is also another new concept which has been included in BNSS. And suppose this person, officer in charge of the police station, he does not take the FIR, then what? Is it the end? No. We can submit our grievance, we can complain it to Superintendent of Police, SP. We can give the FIR information to the SP saying that please investigate into this matter. Officer in charge of the police station is not receiving our complaint. So, we can directly ask the SP, Superintendent of Police, to receive our information. Okay. So, this is like what we are learning in this section. Okay. Let us understand them one by one. See, first of all, a normal FIR, it can be given orally or by electronic communication, both. Okay. It can be given in writing also. Okay. Whatever form it can be given, it means like orally also you can give. By electronic communication, this is the new section, new subsection which says that EFIR, new concept which has been included. But see, one drawback is that if anyone can give electronic, if any person without going to police station, if they start giving electronic FIR, if they start lodging electronic FIR, what would be the consequence? There could be huge misuse of this provision. Any random person, even if I have some hatred against some person, I can simply lodge the complaint, simply lodge FIR by electronically, right. So that it should not be misused, what they have added is that, see, they say that in the case of electronic FIR, the physical copy, it should be signed within 3 days by the person who lodges that, who gives the information. So that is one check which has been included here. Electronic FIR can be given electronically, like there is some portal through that we can lodge FIR, but it is not left like that only. So the police should continue, right? They should start investigation. So if it should have a validity, then it should be signed. If I give electronic FIR, I should go to the police station and sign it. And how many days? Within how many days should I sign? I should sign it within 3 days by the person giving it. Okay. So this is one such thing what we see. Then when it comes to oral FIR, okay, a person has given oral FIR. So it has to be reduced into writing, even if he comes and says orally, or if he gives written complaint also, then that's fine. Or if he says orally, it should be reduced into writing, and it should be read over to the informant, because see, the person may give the information something, the police may write it as something else. So that there shouldn't be a miscommunication, it should be read over to the informant, and it should be signed by the person giving it. Whoever person is signing, whoever person is giving the information, he should sign on that. Okay, so this is said to be the oral FIR. Okay, so FIR, the information has to be given to the officer in charge of the police station, and it is with reference to only cognizable offence. So very important, it is only with reference to the cognizable offence. So every information relating to the commission of cognizable offence is said to be FIR. And see, this is one new concept what I have said, zero FIR. What does this mean? What does this zero FIR mean? See, sometimes what happens? An offence has been committed. When the offence has been committed, suppose it's in Bangalore, offence has been committed. Suppose I was in Chennai, so I lodged a complaint in Chennai. But offence has been committed in Bangalore. The Chennai police is not registering my complaint, because they are saying this is not a jurisdiction. Bangalore people have the jurisdiction. Can they do so? Earlier they used to do so. But now they have introduced the concept of zero FIR, and they state that wherever, let the offence be committed wherever, you can lodge information in any police station. So that's why they have stated irrespective of the area where the offence has been committed. So zero FIR is something where wherever the offence could have been committed, okay, you can lodge the FIR in any police station. To any officer in charge of the police station, you can give the information. That is a new concept introduced here, zero FIR, what we call. And also we see that regarding whatever has been information has been given, that should be maintained in a book. That's one thing they have said, because some proper record should be there, no. So if we have to summarize this, okay, FIR is given with respect to the cognizable offence, and irrespective of the area, it can be given anywhere, which is called as zero FIR. FIR can be given orally, by electronic communication, or by writing. If it is given through electronic communication, the person who is giving EFIR has to sign it within 3 days from taking it on record. If it is given orally, then it has to be reduced into writing, and whatever is written, it has to be read over to the informant, and his signature must be taken on that. This is regarding oral FIR. Okay, and also they should maintain a book regarding what is the substance of the information which has been received in the police. So the officer in charge of the police station is the person who is taking this. Then comes, see, you can see there is a list of offences, right. So these are some of the offences which are sexual offences. These are regarding rape, gang rape, or outraging the modesty of a woman, or insulting with indecent signs, or by way of acid. Under that category they will come voyeurism, sexual harassment, and all such things, stalking. So when such offence has been committed, then a victim goes to the police station, right. Who has to take the information from her? If they know that, okay, this is some information regarding sexual offences, then it should be either the police officer who is a woman. So it should either be a woman police officer, or it could be any woman officer. She need not be police, but information has to be recorded by either woman police officer or either any woman officer. Okay, so very important aspect what we call. So this is with respect to woman, and the next comes when the victim of these kind of offences. Okay, if the victim, if you are the police is recording a information with respect to these offences. These are regarding rape and gang rape. This is what I said, outraging the modesty of a woman, sexual harassment, voyeurism, stalking. This is regarding grievous hurt by acid, and this is regarding word, gesture, intended to insult modesty of a woman. So all these cases are there. So, when that is a thing, when the victim has been given victim is supposed to give the information, and that victim is temporary or permanently, she is a disabled person. It could be mentally or physically disability. So, police cannot ask them to come to the police station and give the information. The police has to take the information either at the residence of that victim or at any convenient place of their choice. Okay, they have to receive the information at some convenient place of the victim's choice, not at the police station, because see, they are already suffering from the disability. Moreover, an offence has been committed against them. In such circumstances, if they are harassed, it could be a harassment. If they are asked to come to the police station, give the information, give the statement, it's a kind of a harassment, right? So, to avoid that harassment and embarrassment, the police are instructed to take such information at the residence of such person, and in the presence of interpreter or special educator. So, when see, sometimes what happens is the person, a disabled person, whatever he says, it may not be properly comprehensible. The person may not be able to understand that, right? So, an interpreter or special educator may be required for this. An interpreter or special educator may be required for this purpose. And whatever recording procedure they are doing, it should be videographed. It needs to be videographed. And also, the police officer, he should also get the statement of this person by a judicial magistrate, because if a statement is recorded in the presence of the judicial magistrate, it has more evidentiary value. Okay. So, later the victim statement must hold good, right, during the trial procedure. This is only an investigation procedure, but during trial the victim statement must hold more evidentiary value. That is why if it is given before police, it does not have much evidentiary value, but if such statement is recorded by a judicial magistrate, it has more value. So, that is why they state that the police officer needs to record the statement by judicial magistrate. Okay. This is also one such important thing what we say. And as I already said, whatever the FIR copy is there, FIR is been registered, the copy of FIR should be given to the informant also, and also to the victim also, because sometimes informant could be a different person, victim could be a different person, victim could be in the hospital, informant he is coming and is informing the police at the earliest. So, for both the persons, the police need to give immediately, forthwith means immediately they have to give the information to the police. They have to give the copy of the FIR to the informant or the victim. Okay. And one more thing regarding preliminary inquiry. So, this is a very new concept introduced in the BNSS. So, earlier in Lalita Kumari case, under very few circumstances they have said FIR needs to be mandatorily registered. They had mentioned, in Supreme Court had mentioned in Lalita Kumari case, it had said that FIR needs to be mandatorily registered if information is given. But this introduction is somewhat a different thing. Okay, this is against such ruling, what we can understand, because what does it say? It says that if an information is given with respect to offences which are punishable with 3 years to 7 years. If an offence is punishable with 3 years or 7 years, and with respect to that offence you are giving the information, then police need not mandatorily register the FIR. He can conduct preliminary inquiry. So, that is one important thing. Okay? Without registering the FIR, he will conduct some preliminary inquiry, and he has time limit of 14 days. He can conduct preliminary inquiry like within the period of 14 days, and then he can decide whether to proceed or not. If prima facie case is there, only then he can proceed, otherwise he may say that no, I am not registering the FIR. And considering the nature and gravity of the offence, he may also proceed with the investigation. Okay, there is no compulsion that they have to conduct preliminary inquiry. He may proceed with the investigation also, and also he may conduct preliminary inquiry within the period of 14 days to register to know whether this is a prima facie case or not. So, why this has been included? Because see what happens is, see these are all cases regarding dowry cases. So many cases are misused, so many offences are misused, right. So, to check whether this is a proper case or not, for that they are considering this. Okay. Then, okay, so now we have understood how FIR is registered, what copy should be given, how should be the victim, who should like when woman police officer has to take the information, all that we have seen. Now, if suppose if the officer in charge of the police station is not receiving our FIR at all, what should we do? We have the remedy. We can send a letter to SP by post. Who is SP? He is superintendent of police. Okay. So, any aggrieved person on refusal by officer in charge of the police station, if he is not receiving the information, I can send the information, the substance of the information in writing, okay, to the concerned SP, to the concerned superintendent of police. So, and that is by way of post. And if SP he receives, what can he do? If he thinks that okay, this is some very serious case, investigation has to be done in this. So, if he finds that, he can directly investigate the case, or what can he do? He can direct investigation to any subordinate police officer. Okay, he himself can direct investigate the case, or he can direct the subordinate police officer to conduct the investigation, and such police officer will be having the equal power. How the original officer in charge of the police station had the power to investigate into a cognizable offence, the same manner even this person is having the power. Okay. And suppose, so this is a new provision which has been included in BNSS. Even if this is not working, SP is also not taking any action, then you can directly apply to the magistrate. Directly you can approach the magistrate, that is a separate case. Directly you can complain, which is known as private complaint. And even if this method is not working by way of FIR, then you can apply it to magistrate, saying that see this is the offence which has been committed, please take some action. So, this can be done. So, this is with respect to the FIR and SP, how the grievance of a police officer has to be taken. Okay. So, this is one kind of question. When you get a question regarding this, you can write this much, whatever how FIR is given regarding victim who is mentally or physically disabled, regarding woman police officer, regarding zero FIR, regarding preliminary inquiry, then when you are complaining to superintendent of police, then when you are complaining to magistrate, all these things you can write point by point, then you will fetch a very good marks. Okay. So, in the next part we will understand how the investigation powers are, how a complaint, how that route, how is that route, like that we can understand. Okay. So, thank you for your listening. See you in my next class. Take care. Bye bye.